Hearing in the appeal, Trin Company of Trinidad and Tobago Limited, and Ryan and another.
Yes, Estelle.
May it please your ladyship and my lords, I appear for the appellant together with my learned friends Mr. Jonathan Crystal and Miss Charlotte Proudman, and my learned friend Mr. Benjamin, who appeared below, appears for the respondents. As you know, this is an appeal from the Trinidad and Tobago Court of Appeal. The majority of that court allowed an appeal in a case which turned essentially on the judge's findings of facts in respect of a well that has, an oil well that has ceased production in 1943, in respect of which the respondents alleged that from about the time they moved to their home, which was some 40 feet from the capped disused oil well, they had experienced either oil fumes or gas emanating from that well, which so affected their health that they developed different respiratory diseases.
Was it only from the well? I thought it was also from the land immediately surrounding the well, which was also under your client's control.
Their pleaded case and their evidence centred on the well. One of their allegations or particulars of negligence was failure to monitor the land around the well, and to the extent that natural gas permeated from deep in the earth to the surface through that part of the, through that land near the well, we would accept that it would be that there's no distinction to be drawn between such gas or gas coming up the well itself. But the evidence of the respondents associated the gas of which they complained to constant leakages of oil and seepages of oil from the well itself.
How did they know?
Rather than natural gas seeping through the earth at that point in the earth. One explanation of what might have happened in the past to affect the respondent's health is the escape of natural gas from the general vicinity, although in our respectful submission, it would be apparent from the evidence and from the judge's findings that there was no such gas or no gas to any significant extent. There's a useful...
Could I just be clear? You say that you accept responsibility to the extent that gas came from the area around the well.
If there was an escape of natural gas from the land close to the well, but not through the well, which was blown over to the respondent's home and caused their medical conditions, we accept that the appellant would be as responsible for that gas as it would be for gas that escaped through the well itself, because it's land over which they were in control and would be responsible for any for failing to take the steps which could be taken to prevent the escape of such gas.
So, I mean, and how do you define the land under their control for that purpose?
The land under their control would, well, I don't think the judge made any findings as to the full extent of the land, but there would be an operating radius round the well, which would
anyway, maybe not unnecessary. Don't worry now, but we'll see if it matters. But there is, I mean, he obviously accepted there was an area within their effective control.
That is so.
Thank you.
And it would be a working area around the wellhead. So it would be a number of feet. But the judge, I don't think that was explored in the evidence, and the judge certainly made no finding about that. But he did refer to it, and it's clear that in leasing the oil well, that would have included a working area round the well head.
Is the highest point of the claimant's case, or was it, 177 of the judgment, or does it go further than that?
Further than 100?
Paragraph 177. Because that looks like a finding that there was in the penumbra around the well both oil and gas.
Yes.
Perhaps it isn't. You must tell us.
Yes, the judge, without defining it geographically, does in this part of his judgment define the area which is round the well, and he refers to the works in 2006. In addition to recapping the well and having fresh plugs inserted at various levels and thicknesses, cement was effectively injected into the cracks and around the well, and the judge held that has been totally satisfactory, and there's been no escape of gas or oil from that area since 2000.
There's no dispute, is there, about 2006 onwards? We're interested in before 2006.
Indeed, but as my lady and your lordships will see in due course, we say that finding for which there's no appeal is so critical that it makes it very difficult for the respondents. It made it difficult for the respondents to succeed in the Court of Appeal, and we say impossible before this court.
Right.
There is a plan in Bundle 2 of the record, page 401, which is of some utility. It's attached to the Rose report that was prepared in April 2006, immediately after the remedial works. And they carried out gas monitoring on the 6th and 13th of April. Those dates are to be seen on page 400. And this plan demonstrates the house of the respondents relative to the wellhead, and you see that it is to the southeast, which is the direction of which a number of witnesses spoke. It also refers to the wind direction. The predominant winds in this area blow from the northeast to the southwest. That is dealt with in the evidence of Mr. Cadogan. It's in his first witness statement, and is not.
I think, could you be careful to stay within range of the microphone? It's not, your voice carries well, but it's for the purpose of recording.
I appreciate that. Thank you, my lord. I was.
No, that's all right. It's
closer to it.
It's difficult to remember. But,
to the west of the wellhead are areas of where there was water on the ground with thin film of oil on top. And and the marshy area that the judge detected would have been in that area to the west of the wellhead. We say that the central finding of fact made by the judge was that he could not accept the evidence of the respondents or of their neighbour, Mr. Sorzano, that there were significant oil fumes or escapes of gas from the well or its vicinity, either after 2006 or before. But having rejected that evidence, there was no other evidence of such fumes or gas upon which the respondents could rely. They called no other witnesses. Indeed, it's a remarkable point that although there was one wife, a mother-in-law and two daughters, other than the second respondent living in the house, that Mr. Ryan's claims included compensation for the diminished value of the house and the cost of acquiring a new property. The co-owner, his wife, did not come along to give evidence to support her husband and daughter. There were other houses in close vicinity, but none of them came forward to give evidence. Indeed, no one ever complained about the alleged oil fumes or gas prior to February or March 2006, when Mr. Ryan made his first complaint. And there was never, ever a complaint from anyone else before 2006 or since. With the exception of one employee who lived locally and who, in 1999, picked up the slight smell of oil fumes, which led to the pit and the drain being dug and installed, and then the regular visits and monitoring that took place subsequently. No one else giving evidence at the trial ever smelt anything in the vicinity of the oil well. On the contrary, there were quite a number of witnesses from the appellant's side, and it was not suggested to any of them that whenever they made their regular visits, they were entering an atmosphere where you had the permanent smell of gas or oil fumes. The evidence of the respondents is significant for this reason. Their evidence as to their experience at home after the 2006 work, as well as before, was that whenever they came home or were in the property, they felt very ill. But if they were away from it, they felt very much better, and they seemed to recover very quickly. I will show you the evidence in a moment or two, but the significance of that is this. Either that evidence was simply untrue, they either lied or fantasized, and none of that ever in fact happened, in which case that itself would be a good reason for the judge rejecting that evidence. But to the extent that there was any truth in it, after 2006, it must follow that there was something else happening inside the house or in its vicinity that was causing their medical condition. After April 2006, it could not have been anything emanating from the well or its vicinity, because the judge's findings that there was nothing, there was no more, or there were no oil fumes or gas after April 2006, must mean that if they were experiencing some ill effect in their home after April 2006, which they did not experience when they moved away from it, then the cause must have been something else.
Well, does that follow? I mean, the subjective sensation of individuals who suffer respiratory disease or interstitial fibrosis isn't necessarily and inevitably connected with the underlying cause. I mean, you can't, I think, extrapolate from the circumstance that they continued to experience unpleasant sensations after 2006, that there must have been some other medical cause for their condition. Can you?
Our primary submission is that there were no gas fumes or there was no natural gas or oil fumes or vapours in or in the vicinity of their home after April 2006.
Well, does that imply that you are not in a position to dispute that there were before 2006?
We say that the judge was entitled to reject their evidence that there were such fumes and gas before April 2006, and with the rejection of that, with that being a finding open to him on the evidence, and with that finding having been made, it must follow that whatever the cause of their respiratory diseases, it was not oil fumes or gas from the appellant's oil well. There were other causes unrelated to oil and gas which could have been responsible for the second respondent's RAD.
It's a commonplace incident of respiratory disease that those who suffer from it are not necessarily aware during the time of inhalation of the noxious fumes or gas of any unpleasant sensation. And it seems to me difficult to say that simply because the judge has rejected their kind of subjective reaction to fumes and oil, that must inevitably be determinative of the issue as to whether exposure to these noxious substances was causative of their condition. In other words,
yes.
People suffer from all manner of respiratory disease without being aware during the time that they've been exposed that they're suffering from any exposure that causes them subjective symptoms.
Well, they themselves drew the conclusion by March 2006 that it was the gas and oil fumes that had invaded their home which was responsible for their respiratory conditions. And having reached that conclusion, and they reached it partly by their alleged experience that when they were away from home, their health was much better, and when they returned home, it immediately deteriorated. But it was as a result of they having reached that conclusion that it was the atmosphere of their home that caused their diseases, that upon reporting that as part of their history to their two medical experts, Dr. Trotman and Dr. Bagan Khan, that the latter concluded that there was a link between the fibrosis and the RAD, which they diagnosed, and the home environment which had been reported to them. Can I take you, my lady and my lords, to the evidence, firstly, of Mr. Ryan. The relevant evidence is in his first statement, which is in Bundle 1 of the record at tab 5. And at page 171, paragraph 3, you see the reference to his other two daughters. Over the page, at paragraph 5, you see he's very clear that before February 06 as well as after, the defendant wrongfully caused oil to seep from the said oil well. He put it down to the oil coming out of the oil well, not natural gas, to overflow from a pit located nearby, and to arise therefrom unpleasant and noxious smells, gases and fumes, including hydrocarbon fumes, as well as airborne sediment, all of which spread to our property throughout our house and the surrounding area. At page 176, at paragraph 14, he refers to a letter of complaint that he wrote in February 2006. This was after it became apparent that the remedial works were to be undertaken. They were in the planning stage then. And he said, following my letter, the problem continued unabated, my health deteriorated significantly. I had tremendous difficulty in breathing, and so on.
Mr. Tager, did you just say that the planning works were undertaken before your company was alerted by the first respondent to his complaint?
No, my lord.
Then I misunderstood you, and
I said it was before his letter. The history of the very brief history of the works is as follows. There had been complaints at the turn of the year from Mr. Ryan, oral complaints. And at the same time, the appellant was concerned that because the area around the pit was being used as a rubbish dump by the local population, this being the dry season, they were concerned about a fire that would be aggravated by the presence of oil, albeit in small quantities, in between the monthly or fortnightly emptying of the pit. And so for that reason, they decided to carry out the remedial works. That was, even though they did not accept that the complaints of the first respondent were justified. And it was whilst those works were at the planning stage, which is February, that the first letter of complaint is written on the 9th of February 2006.
So what tests for oil smells or gas did your company make before the remediation works were undertaken?
Their personnel had been, and as well as a contractor, had been attending approximately monthly from 1999 right through to 2005. And if there's gas present in any significant amount, you pick it up with your nose. You don't need a machine or a tester to tell you that there's gas in the air. Before they actually carried out the first welding operation, which was to attach a device called a blowout to the top of the well, it was necessary for safety, health and safety reasons, to carry out a test of the atmosphere to make sure that there were no explosive gases in the vicinity, even in small volumes. And a gadget called a 4-gas tester was used, and it showed zero or virtually zero readings of any relevant gas.
So can we take it then there was no testing by machine in the period between 1999 and 2006?
That is right.
They just
That
went on.
test took place before.
Yes, the only
began in 2006.
yes, the only reason there was this testing, and that took place before the welding, was simply for health and safety reasons, where it was necessary to test for even minute quantities.
I think I was really asking you about wider testing for fumes and gas. I think the testing to which you refer is it safe for us to put our metal top on?
Indeed.
And so, or will everything explode? So the test, correct me if I'm wrong, to which you have referred before that was done, was focused upon that.
Yes.
And I think you're saying, by inference, that when the oral complaints and then the written complaint of the first respondent came in, there was no general testing of fumes or gas in the area.
In the area being that radius round the
Yes.
well. The answer, my lord, is yes. There were no such tests But if there were escapes of gas in that area, or even in adjoining areas, they would be picked up by the nose. The nose is a very effective mechanism. It is that which the judge used when he went on his sight view.
Well, is there any scientific or empirical evidence for the efficacy of the nose as a detector of gas?
Is there any evidence it isn't? I mean, the Ryans ever...
Well, let's approach the first question first of all. I mean, is there any evidence that nasal detection is a reliable source of information?
There was evidence that natural gas can be detected by smell, and it was taken for granted that oil fumes can be detected by smell. Mr. Archie, at page 1134 of the record, says that natural gas is colourless, but you can smell it. It was not suggested on behalf of the respondents to any of the appellant's witnesses that you could have gas in the vicinity of the oil well that emanates from the well or its immediate, or the area immediately adjoining it.
This is Mr. Archer saying there tends to be a smell because of the gaseous hydrocarbon molecules. Is that it?
That is right.
It's,
It was not suggested.
it's the hydrocarbons that do the damage, isn't it? Yeah.
But it wasn't suggested to any of the respondents' witnesses, to any of the appellant's witnesses at the trial, that you could have gas of low density that could harm the health of that could be blown to the respondent's home and not be detected other than by a machine. On the contrary, if it is very low density gas that is seeping out of the earth, the prevailing winds would blow it away from and not towards the respondent's home. His case was not based, although the majority judgments at one point talk about VOCs of low density possibly being responsible. This was a theory that was not advanced at the trial and was not explored with any of the respondents' witnesses, or indeed touched on by either of the respondents' experts. They were dealing with hydrocarbons. That's what the pleaded allegation was. That is what the respondents referred to in the course of their medical history: oil, fumes, and smells. And it's that which resulted in the diagnosis and the opinions expressed by the two experts for the respondents. If I can return to the evidence of the first respondent, at page 181 of the record, paragraph 22.1, that's where he refers to having rented a property, and therefore he and his family were living away from the 1st of April until the 31st of July. But he says on page 182 at the end of paragraph 22, on our return, however, my breathing problems reverted as before. In his...
It's a reference to 2004. Is that a mistake?
That's a typographical error.
Very well, thank you.
One can see that from the...
Yes, very well.
From the handwritten receipts that he relied on.
So it should be 2006.
It was all in 2006.
Yeah.
So rendered it in July and returned in...
After 3 months. So he says they returned on or about August.
That's not true.
And they say that 3 months away from the emissions of the oil well, obviously our home was refreshing. By short, he doesn't say, and we came back and we were glad to find that as a result of the remedial works, the atmosphere around our home was now clean. On the contrary, his evidence was, as you've seen, and he reinforces that at page 185 in paragraph 26, where he says in the 5th line, I feel healthy when I'm away from my home, that continuing to reside in our home is not an option. Then later on in that paragraph, he says, not dissimilar to when the defendant paid for our temporary relocation, they ought to compensate me for permanent relocation as well. In this regard, I say, it's only when I'm away from my property that I feel healthier. So that's how he expressed it, and he's speaking of the period after 2006.
Does he in fact say somewhere, I expect he does, Mr. Tager, but I haven't got it in my head, does he in fact say somewhere that after his spell away in the rented accommodation, so from August 06 onwards, there remained an overpowering smell?
Well,
he certainly says he felt bad.
The answer is yes. I'm about to take your lordships to your ladyship and your lordships to the oral evidence. We are in bundle 4. First, we go to page 1076. That's his, he gave evidence over a number of days, but at page 1076, which is the first reference, in the lower part of this page, he refers to properties in the vicinity, and he thought there were about 4, and penultimate line, 2 are close to his home. Over the page 1077, about 2/3 of the way down, he says, don't quite agree, from 1965 to the present time, I get the scent of crude oil every day. Well emits gas and I smell it. So he's not distinguishing between the two periods. At page 1079, talks about, at the top of the page, talks about his neighbours. When I visit them, I do not get the same smell all the time. I imagine I visited them in 2006. I got the same smell in 2006. I got the same smell today, both at my neighbour's house and at my house. Page 182. At the top of the page, about 6 lines down, he's asked, it says, answer, it should be a question. First time you noticed this well leaking, answer 1965. Then, in the middle of the page, since 1965 had seepage correct, since then you had unpleasant smells, yes. First complaint was 2003, he said yes. Then a few lines down, about a quarter of the way up, why did you not complain for 30-odd years about the unpleasant, noxious smells? I had no idea that the smells and noxious gases were affecting my health. It was then put to him that there were no such smells. He said they always existed.
That reference to 2003 and 2002 is obviously a mistake, is it?
No, that's what he was saying, that in 2003 he says he made oral complaints. Not written. His first written complaint was 2006.
But in his, well, the judge recorded his evidence that the problems first arose in early 2006.
This is...
Anyway, that's what he says.
Yes.
Yeah.
Certainly he was making an oral complaint at the beginning of 2006 because, as I explained to my Lord Wilson a few minutes ago, it was that oral complaint that, plus the fire risk, that led to the decision to carry out the works that spring.
Now, it was just paragraph 48 of the judgment where the judge recorded his evidence. The cause of the health problems of which I complain in this action only surfaced from about February, March 2006.
Well,
And she, and then
that was the judge's finding. I'm just showing you the relevant evidence. At 1088, he and the note has conveniently highlighted it. He says, crude oil is still creeping up from the western side of the well. Crude oil can emit different types of gas. I was speaking, up to today, as we speak, there is crude oil.
I'm sorry, where is that, please?
1088, all in bold at the top, about a third of the way down. And then in the next line, in the immediate vicinity of well 94, oil still creeping up even as we speak. So his case was that in 2009, when he's giving evidence, December 2009, he is saying that the well is still leaking, and the fumes of which is making life so uncomfortable for him is coming from an oil well still leaking in 2009. Uh, 1103. This is the second occasion he's giving evidence. And in the middle of the page, in an answer, he says, whenever I go away and come back, I'd have the symptoms. Whenever I go back there and smell the oil. So it's the oil he's smelling. The symptoms are not as severe when I'm away as when I am at home. Over the page, 1104. There's a question put in the middle of the page. In fact, there are, apart from the area where the well is in that environment, do you get the smell of oil or hydrocarbons? No. So he's quite clear there's nowhere else in near his home where this could come from. So if we go there now, we're not going to get the smell from anywhere else? No. And he insists that is true. 1107. Says about three-quarters of the way down the page, suggesting to you that because of the shallow depth of oil sands in the area, vapours you smell there could have come from the oil sands. Answer, it came from the oil which was leaking from the well. Again, it's put oil sands, no, it came from the oil well itself. That's the case that he was insisting on. And then there were some answers to the learned judge at page 1202. On, I think, the third and final occasion when he gave evidence.
Forgive me, just give me that reference again, please.
1202.
1202, thank you.
That's right at the end of the trial. But by now he's giving evidence in May 2010. And the judge asks him at the top of the page, can you describe the state of affairs in the vicinity of well FZ 94 right at this point of time? And he says, presently in the immediate vicinity of the well, there are no apparent leaks of the sort, but on the western side, 30 to 40 feet, there's an area where you still have cropping up there. And the judge put it to him, you said there is oil coming up. Whenever you dig the soil, you'll see the area saturated with what appears to be oil. And then in the middle of the page, he's asked about smells. The smell, I can't describe the smell, but whenever I go in that area, I feel very nauseated. I start to cough. And he explains that that area is about 65 to 70 feet from his home. And then over the page, after giving the dimensions of the patch he describes, in the middle of the page, from your house, do you smell what you say you smelled when you go to the vicinity of the oil-saturated oil that is there now? And he confirmed that that was so. So that's his evidence.
So where was that?
That is page 1203 in the middle of the page.
Right, thank you. Was this before the site view?
This is before the site view. Oh, yes. I don't think the judge had yet announced that he was taking a site view. The judge took the site view after the conclusion of all the evidence, but before final submissions. The second respondent, her witness statement is in the first bundle at tab 4. Paragraph 5, she says in words almost identical to her father's that both before as well as after February 2006, she has experienced unpleasant and noxious smells, gases and fumes. At page 163, she refers in paragraph 11 to that experience. In paragraph 12, she says, despite the efforts of her father, the problem continued unabated and her health deteriorated, tremendous difficulty in breathing. Paragraph 15 at the end, she said there was a vast difference when they lived in the rented premises. And in paragraph 21 on page 165, although the well was capped in 2006, oil still seeps to the surface on the western side of the well. Her oral evidence is in bundle 4, 1027. At 1036, she's asked, this is about 3/4 of the way down the page, so you do not know if smells of which you complain came from the well. I think it's highly probable. Why? Because of the mere fact that there is oil coming up in abundance, so feelings I get would obviously be coming up from the well opposite my house. It's put to her that was untrue, and she says, living there 24 years, seen it, witnessed it, sure that it does, used to look like a small lake. And then she describes that lake. At page 1040, she's asked about 2/3 of the way down the page, last time you visited the well, last year, can't say if beginning or end. She's giving evidence in 2009, so she's talking about 2008. Did you see any oil there? Yes, a reasonable amount. Another lake, no, not from, and it was put to her that it wasn't from the well, and she said, no, not true. Do you know where the oil there is coming from? No, I haven't checked the wind direction. And then 1041, about 1/4 of the way down, put to you that well has not been emitting oil since it's been capped in the 1940s, and she says, not true. You then have the judge taking a view and satisfying himself from what he saw and from what he smelt that there was no oil either coming out of the well or coming out of the ground in the vicinity of the well, no smell of oil fumes and no smell of natural gas. He did detect a marshy area and refers to it, and plainly he is referring to that marshy area as an area which gives off a smell which he detected. So my lady and my lords can be satisfied that his nose was capable of detecting smells. And it was a marshy smell. A marshy smell is the smell of decaying vegetation, and I dare say in that part of the world it can include decaying insects and maybe other animal life. And the judge then went on to visit other areas where he did smell oil or gas associated and fumes associated with oil. So he is therefore contrasting the actual smell of gas which he experienced well away from these premises with the absence of such smell in the vicinity of the well or the respondent's home. And in our...
Is the object of a site visit by a judge to understand the evidence or to collect evidence?
It is both. And as I'll take you straight away to 2 or 3 authorities on that. But what you see with your eyes on taking a view is real evidence.
It depends what the issues are. I mean, here, I think your point is that both witnesses were putting very much on there being cells now, which the judge would be able to experience, I suppose.
Yes, indeed. The judge was only able to use his experience of the site view in order to judge the truth of what he was being told.
Yes, I mean, if they had said, no, it all got much better after 2006, then that wouldn't have been very relevant.
Then the purpose of the view would have been very limited and may not have taken place at all. But because I haven't taken you to the evidence of Mr. Sorzano, but Mr. Sorzano's evidence is in a similar vein. I'll just give you the references. In his witness statement, in bundle 3, page 644, paragraph 6, he said oil seeping from the well both before and after 2006. At page 645, paragraph 8, there's still an area of 40 to 50 feet west of the well where oil seeps and contaminates. In his oral evidence, bundle 4, page 1094, he refers to visiting his neighbours where you can pick up the smell, although he said it's a lot less now. And in 1099, that after 2006, the oil continued to leak and he experiences slight odours every night. The authorities on the evidential value or evidential nature of a view include the following. The first one is the case of Gould and Evans. It's in the second volume of Authorities at tab 14. It's a decision of the Court of Appeal. It was a personal injuries case involving injury at work.
Sorry, we haven't been given tabs electronically.
So sorry, it's page 2154.
2154, thank you very much.
2154.
Thank you.
So the judge viewed the factory and also viewed a demonstration of the mechanical operation which took place when the plaintiff was injured. You'll see from the headnote on that page, per Lord Justice Denning, a view is part of the evidence just as much as an exhibit. It is real evidence. At page 1191, Lord Denning says, it's a fundamental principle of our law that a judge must act on evidence before him and not on outside information. And further, the evidence on which he acts must be given in the presence of both parties, or at any rate, each party must be given the opportunity of being present. On this occasion, the judge was accompanied by the lawyers on both sides. It's not one of those cases where the judge went along on his own to spy out the land or to smell it. Speaking for myself, I think that a view is part of the evidence just as much as an exhibit. It is real evidence. The tribunal sees the real thing instead of having a drawing or photograph of it. Well, we could say the tribunal smells the real thing instead of having it described. But even if a view is not evidence, the same principles apply. And
What actually happened in that case?
the actual decision in that case.
Yes.
New trial.
Because?
Yes.
Well, one of the
The answer is a new trial was ordered. One sees this at the end of...
Because the plaintiff wasn't there?
Yes.
Right.
Yes, indeed. Perhaps my next authority is one which is the case of Tito and Waddell. It's the judgment that deals with the contested application as to whether or not Mr. Justice McGarry should go out to the South Sea Islands. It begins at page 2318. And one of the reasons why it was contested was because of the time it would take and the costs involved. And at the bottom of page 2321, at the top of page 2321, there's a paragraph that begins, as against this expenditure of time and money. That is where Mr. Justice McGarry explained that he would be away from London for 17 days with just his clerk accompanying him, and he deals with the costs and the inconvenience of all that. And then dealing with the law at the bottom of page 2321, he says, I've already referred to 3 propositions based on Order 35, Rule 8. There's a 4th which seems to me to be of fundamental importance. That concerns the juridical nature of a view. At one time it was said that the function of view was merely to enable the judge to follow the evidence. However, since Buckingham and the Daily News, I do not think it can be that the function of view is thus restricted. And in Tameshaw and the Queen, reinforces this approach. Lord Justice Denning put the matter succinctly in an earlier case, which is the one I took you to, where he said at page 1191, and you've seen that. And it was this doctrine that was applied in Buckingham and Daily News. What a judge perceives on a view is itself evidence in the same way as what he sees and hears in the courtroom. Just as a portable object may be brought into court and being made an exhibit become real evidence, so if the judge duly views a place or object which cannot be brought into court, that place or object provides real evidence through the medium of the judge's eyes, ears, touch, tongue, or in one recent case before me, his nose. We even have a reference to that, Penn and Wilkinson. On this footing, the tendering of real evidence no longer depends upon the res being portable. One result of a view having this nature is that the present application must be regarded not as a mere application by the plaintiffs for me to view Ocean Island in order that I might better understand the evidence, but an application by the plaintiff to tender certain evidence.
Mr. Tager, it was I who started this hair running. Thank you for drawing our attention to these 2 authorities. Obviously, what was crossing my mind was that if Mr. Benjamin had wanted to cross-examine the judge, it might be rather difficult for him to do so. But when all's said and done, there is now no dispute but that there was no significant amount of fumes or smell of oil after 2006. And so really, all this is to the side of the remaining issue.
If the judge had not indicated his experience of the view until after he had delivered judgment, and if those who attended on behalf of the respondents had felt the judge had smelt something, had failed to smell something which was so obviously to be detected by the nose, then they could have raised that on appeal and put in, by way of fresh evidence, the evidence of those from the legal team or others who had attended the view in order to demonstrate that the judge had just got it wrong.
I think what I was suggesting was that you haven't got unlimited time. Thank you for explaining this, and perhaps you should move on.
I shall indeed. I now move to the medical evidence, because the medical evidence is of significance because of the way that the diagnosis was linked to exposure to hydrocarbons. We start with Dr. Trotman. Her statement is in the first bundle at tab 6, and I just draw attention to the fact that in page 287, under assessment, you see that she writes, this patient has chemical pneumonitis brought about by exposure to hydrocarbon fumes. She doesn't talk about it being hydrocarbon pneumonitis. She uses the same term of art as did in fact, the two witnesses, the two experts, but in particular Professor Seamongle, who were called by the respondents. In her oral evidence, in Bundle 4, page 1063, she describes the condition chemical pneumonitis at the 5th line.
So which page again?
1063. Three lines up, she says sulfur dioxide can lead to chemical pneumonitis. When dealing with other possible causes, she deals with the sugarcane fields around at the bottom of page 1064. That's in the context of the second respondent's RAD. Importantly, 1065, it was put to her, you don't know, apart from what you were told, what is in the environment at Hinkling Village. Answer, apart from what is in history, which is what she told me. She's not visited it. And then at the bottom of the page, 3 lines up, gas well, 30 feet. That information is what he told me. Did he tell you oil well was abandoned or plugged? She couldn't recall that. At the top of page 1066, she did not know which gases came out of an oil well. And 1067, 2/3 of the way down, your conclusion that it was chemical pneumonitis was based on his history of being around oil well, that and the CAT scan and spirometry. CAT scan and spirometry told you he had pneumonitis, but would they tell you it was chemical pneumonitis? No, they would not. So conclusion that it was chemical was because of the history. Fair assessment, answer, yes it is. And at the bottom of page 1068, it's a fair assessment to say I'm not in a position to say what chemical caused the pulmonary fibrosis. And then on the next page, she says, not much literature on hydrocarbon pneumonitis. I do not know of studies which show a link to hydrocarbons. Literature shows any chemical can cause. So she, like Professor Seamongle, was unaware of any studies showing the link. The evidence of Dr. Bagan Khan in her original report, which is in the second bundle, at tab 16, at page 503, she says, three-quarters of the way down, just at the end of that long paragraph,
Sorry, which page again?
503,
503. Thank you.
there's a line that begins with the word hydrocarbon fumes. The latter is known to produce pneumonitis, which over a period of time could lead to fibrosis. So she just put it in that passive way without citing any source. She then, in the next paragraph, refers to the child of the household who turned out to be the second respondent, and hence her conclusion at the bottom of the page. Her supplemental report is in the supplemental record at tab 1. At bundle 2, which I don't need to take you to, bundle 2 at tab 17, we have got the article which it is said that the judge did not treat this as so affecting the reliability or credibility of Professor C. Mungle that the judge should not have relied on the professor's evidence. That was, in fact, a textbook.
What's the reference, please, Mr. Jager?
The reference?
The article.
The article. This is the article. It's not an article. It's an excerpt from a chapter in a textbook. You've got the.
What's the reference to?
It's page 505.
217.
Yes, it's bundle 2, tab 17, page 505.
Thank you.
And you see, it's a book published by two American academics, an associate professor and an associate adjunct professor. It's a textbook which was on the recommended reading list of a 7-day course that Dr. Bagan Khan attended. And it was recommended in the reading list, and that's how she came to acquire this book. She also said in her evidence that when she went on a 7-month course to England to obtain her diploma from the Faculty of Occupational Medicine, it was not one of the recommended books for that 7-month course. And in a chapter that advises doctors generally on how they go about investigating and identifying a large number of medical conditions that could be associated with the patient's environment. And you just need to look at the headings on page 506, which include, interestingly, this was put to her at the end of her cross-examination, on-site investigation. In the occupational medicine clinic setting, one further step is linking a patient's disease and his or her workplace. Same would apply to home environment. Involves on-site investigation, and then that is spelled out. And she accepted that she didn't go to the respondent's home, nor indeed had Dr. Trotman. There is a table on the right-hand side, table 16-3, which is headed Common Radiographic Findings in Occupational and Environmental Lung Disease.
Page? Sorry, I didn't catch the page.
Page 507.
Thank you. Got it.
Table 16-3. And in the left-hand side, 3/4 of the way down, immediately after fire smoke, you've got hydrocarbon pneumonitis. Yeah. And that was it. This is not a study. This is not the work of some medical academics who have carried out research and who have linked oil fumes, natural gas or the like, to a form of pneumonitis. It is one of a large number of conditions included in this table, without any citation to any research.
What's the table purport to suggest? Is it suggesting that hydrocarbon, sorry, I can't quite read it,
Says common radiographic findings.
pneumonitis in occupational and environmental lung disease? And what is the suggestion that's being made by the paper or by the extra?
This textbook suggests, but without saying why, and without anyone ever finding a research paper that backs it up, that the authors of this book have included this condition as being related to lung disease. And in order to, I showed this to you first of all, so it's,
I mean, they're saying it's a common radiographic finding.
yes.
But we don't know. I mean, if it is, one would expect there to be some reference to it in the medical literature, but there's we don't have that.
Dr. Bagan Khan, who had asserted that there was that link, but in her original report, and didn't say anything more about it in her supplemental report, she's cross-examined on it. And at Bundle 4, page 107, Bundle 4, page 1045, that's where it's put to her, 4 lines down. He claims to have been exposed to hydrocarbon fumes based solely on what he told you. Correct. And in the middle of the page, I didn't know if hydrocarbon fumes in vicinity of his house. And on top of the next page, the medical history had been provided to her in a letter from Dr. Trotman. She didn't have that letter. The bottom of page 1048, the history of exposure, the history Mr. Ryan gave me. And page 1049, about 2/3 of the way down, in your report you say protracted period of time. I had in mind a period of time you said he lived in Hinckley. I don't know there were hydrocarbon fumes being emitted. Your conclusion based on that is not of your own knowledge. Partially, my own knowledge is looking at the results, tests and pathology. But if you look at these results alone, you can't conclude that it has anything to do with hydrocarbon fumes. Yes, I can't conclude. Where do you find this knowledge that hydrocarbon fumes can produce pneumonitis? Answer in texts. She puts that in the plural. I can produce texts which illustrate the changes in lungs due to hydrocarbon exposure. So that is what she's promising at this stage of her evidence. At page 1053, just before the words re-examination, she says, textbook, I have refer to hydrocarbons, pneumonitis, and then she says no quarrel with Dr. C. Mungle. And then she backtracked on that last point. But she's asked, a quarter of the way down, page 1054, for details of the textbook. And she came out with a description of the one at tab 17 that we just looked at. She came back the next morning, page 1055, and she brought the book and read out from the title page. That's then exhibited at page 1056. And she explains at the middle of page 1056 that the text was recommended by the Occupational Health and Safety, and she talks about the course that she attended, and on the college website got a list of books, and she says at the bottom of that page, that it was in 2 parts, 2 days and 5 days, but over the page, her diploma was from England, Faculty of Occupational Medicine, United Kingdom. This book wasn't mentioned, the faculty diploma, 6 to 9 months, that was the course. So the texts that she promised that shows the link turned out to be this book. Dr. C. Mungle, in contrast, had said in his evidence that he had carried out, he's a specialist in this field, he knew of no such link, that for the purposes of his report, he had carried out a very extensive search and found nothing. He found no scientific paper that linked exposure to oil fumes or natural gas with fibrosis or other lung disease.
What, any lung disease? What, any lung disease?
I'm so sorry, with the respondents' lung diseases.
Fibrosis
And RAD.
and pneumonitis?
Well, pneumonitis is a precursor, isn't
Yes,
it?
Absolutely. It's an inflammation of the lungs, isn't it? And it's common ground, as I understood it. Perhaps
yes,
I've got it wrong.
it is.
That could be caused by irritating inhalations, such
I'm
as...
just going to, before I reply, I'm just going to
Yes,
remind
please.
myself, because my notes are not entirely clear on this. If we go to Bundle 2, tab 20, at page 575, he poses that the question he poses is this man's hypersensitivity pneumonitis, stroke pulmonary fibrosis, mild, caused by hydrocarbon fumes? His starting point was to accept the diagnoses of Dr. Trotman and Dr. Bagum Khan. That is why he didn't see or feel any need to actually see the two patients. He then describes their conditions as he understood it. He wasn't challenged on that. Two-thirds of the way down page 576, he shows in Appendix 1 the results of the searches he carried out, and it yielded 230 pages. And the only one that had any remote connection involved a New Zealand study that related to gassing rabbits over a prolonged period. But he says, as my literature research has shown, this hypothesis has not been substantiated by further independent research, and there are no publications showing a relation between pneumonitis and volatile organic compounds such as hydrocarbons in humans. Thus, on balance, I conclude there's no evidence for a causative role of hydrocarbon fumes in human lung pneumonitis. He was cross-examined, Bundle 4, page 1185. At page 1186, towards the bottom, he's asked whether he knows about the American professor's textbook.
Sorry, could you give me the page reference?
1186.
Thank you.
He is taken to page 213, which corresponds to page 507. That's the page with that table on it. And he says, I see hydrocarbon pneumonitis as a cause. It's not a term I use. Term I would use would be pneumonia. And then he makes a few more comments. Then he was asked in the middle of the following page about the term hydrocarbon pneumonitis. Did you search for that term? He said, didn't search for it, he's never done so. Not even when the lawyers for Petroleum drew your attention, he said, yes, I did over the weekend. I was not surprised by the response. I got responses. It was the first time I saw the term, having got responses over the weekend. And he didn't print out those search results.
Well, I'm not sure whether it's this section of the cross-examination, but Justice of Appeal Smith at 2528 says that Dr. Simungle's opinions were seriously discredited by cross-examination. He revealed that he had previously stated that he did not find any literature making lung disease like pneumonitis and fibrosis to hydrocarbon fumes, but a recent internet search had revealed such a link. Do you challenge that finding of...
Yes, indeed. It was totally unjustified. He makes this good by the footnote that refers to pages, to 3 different pages of the notes, which I'm about to take, my lady and my lords. But I've already made the point that page 506 and 507 is not a study. It is a textbook that makes an assertion without citing a source.
I mean, it's not clear, certainly to me so far, whether this textbook is the sole source of any discovery by Dr. Simungle.
His evidence was clear that he knew of no other source, and when he as an academic is speaking of a source, he is talking about an academic paper. He gave an example of a paper that involved experiments in New Zealand on rabbits. And another example, another document that was put to him in cross-examination, perhaps I should show you this before we go to the notes of evidence, is in bundle 3 at page 20, at tab 37, page 652. This is an article in a journal called the Journal of Occupational Health. It deals with, it's a study that took place in a Korean university on the factors related to the prevalence of respiratory symptoms in workers in a petrochemical complex. And this is an article that runs all the way to page 658. And it's a typical, this is what one would call a study. Data is obtained and analysed, commented on, discussed, and conclusions reached. There is no such study that makes the link between exposure to hydrocarbon fumes and fibrosis or RAD. That was the evidence of Dr. Simungle.
But what does this say about
this is
possible effects of hydrocarbons?
This speaks in... This makes no reference to hydrocarbon fumes. It does refer to fumes and vapours in a more general sense, but you will not find the word hydrocarbon in the article. At the page 657, top right-hand corner.
Dusts, solvents, metals, and vapours.
Yes.
What about the vapours?
Oh, yes, it talks about vapours. Vapours in a petrochemical complex. But whether they come from the petro or whether they come from the chemical is not discussed in the article. This article speaks in general terms of vapours, but we do not know whether they are hydrocarbon vapours. Indeed, we do not know whether in a petrochemical complex the machinery inside is designed in such a way that one ever gets a chance to smell the oil that comes in. It may be that the vapours come just from chemicals that are added to oil in the refining process or in the course of manufacturing other byproducts. Yeah. But I put this as an example of a journal, and it's one that he was cross-examined on. At page, the footnote that supports the point that the judge made at this point is footnote 18, and the references are 161 corresponds to 1187.
Sorry, footnote 18.
It's footnote 18, which
the judge,
which of the judge on page 2528.
And that corresponds to
161 corresponds to 1187. 167 corresponds to 1193, and 168 corresponds to 1194. And if I can take you to those references.
yeah.
161 is the page we just looked at, 1187, where he said he wasn't familiar with hydrocarbon pneumonitis, searched the internet over the weekend, and had found references to it. Well, that is not a recent internet search revealing such a link. The judge completely misunderstood that evidence. If that's the recent internet, his recent internet search is just a search against that term, and he found that that term pops up if you Google it. That's all. Not that he found a study that linked hydrocarbon fumes to the respondents' lung diseases. Once at page 1193, which corresponds to 167, he is cross-examined on this, the career research in the Journal of Occupational Health. He said in the middle of the page he couldn't recall if he'd come across it, and then makes the point that the article deals with petrochemical complex. Question, is it that you've been able to make a link between pulmonary fibrosis and exposure in a petrochemical environment? Yes. Is a fuller answer that in fact you've come across a link between pulmonary fibrosis and exposure in a petrochemical environment? Clinically, I've not seen any case of pulmonary fibrosis which I can link to exposure to hydrocarbon. And I should just pause and make this point. He is not just a theoretician, he's not just an academic. If you look at the first part of his statement in Bundle 2, tab 20, page 572, you don't need to turn this up, he deals with his background, and it's quite clear from that that he has clinical as well as academic experience.
What he says is, clinically, I've not seen any pulmonary fibrosis which could be linked to hydrocarbon. I have seen acute respiratory diseases. Pulmonary fibrosis must mean comes closer to the end stage of the insult. In other words, it's a secondary stage of the disease, isn't it?
He's seen the disease, but he's never had a clinical experience where it was linked to hydrocarbon.
I see.
He's not questioned further about the link the link to a petrochemical environment where you can have non-hydrocarbon fumes and vapors.
Yeah.
It's put him at the bottom of page 1193, low level of fibrosis, and it's connected, linked to petrochemical industry. Answer, yes, I've seen that, but not linked to hydrocarbon. I've seen other diseases, sarcoidosis, not linked to exposure to hydrocarbon, even though they work there, their condition is not linked to the environment. And this, page 1194, is the third of the pages referred to by the judge. He talks there on that page to the rabbits. And in the middle of the page, it's put to him that volatile organic compounds easily go from liquid to gas. He said it's reasonable that volatility enhances risk of aspiration as a matter of logic. Then various VOCs are put to him, He says, when crude oil is found in Trinidad, common for it to be found with sulfur dioxide, and he didn't know if that was true, but he'd heard about hydrogen sulfide. And finally, at page 1195, middle of the page, he says he hasn't taken a history from Mr. Ryan, not seen investigation on his home or FZ 94. None of these would have enhanced my opinion. So we have, what is not put to him in cross-examination is a single study. The only two, the relevant literature, as the judge referred to it, is nothing more than the table at page 507 and the article in the journal at page 652 to 656. And we say it was simply not open to the judge to have reached the conclusion that Dr. C. Mungle, as an expert, had been totally discredited by what he called a recent internet search revealing such a link. There was no such search or link.
Well, there was a search.
There was a search. I said such search. Yeah. The search was against the term hydrocarbon pneumonitis. He said he found a number of, there were a number of hits, but he wasn't asked any further questions.
Yeah.
He wasn't asked, did any of them lead you to a study of which you'd not been aware? And so we don't have, we have no evidence that there is, and he's an expert witness, and had he found such a study, one would have expected him to have told the court about it. After all, he had, before the beginning of his evidence, produced something which is clearly not what the judge had in, what Justice of Appeals Smith had at this part of his judgment. I move on now to the next topic, which relates to the testing of gas before the 2006 works, the use of the 4-gas testing gadget. I should make this point in relation to this aspect of the evidence. At page 2531 of the judgment,
Do you mean 253?
I mean 2531. 2531.
What's the paragraph number?
Oh, it's in two places.
It's in the middle of paragraph 36.
Yes, it's in various places.
Yes. In the middle of the paragraph, he talks there of Mr. Jurowell, who's called on an expert on behalf of the respondent. Cross-examination saying seepage of oil and gas into the well casing during the 2006 BPA cells would have the underground reservoir as its source. And he refers there to notes of evidence, page 137. But if one were to go to 137,
So what's the electronic?
it's page, I'm so sorry, 1163. 1163. I mention this just by way of example. There are others, but I haven't got the time to criticise every single line of every single of this judgment. One just sees at the top of page 1163, the question is put, at the bottom of page 1162, it was put to him the seepage was from outside the well bore, yes. Seepage outside well bore would have reservoirs at source, correct. So it's the seepage outside the reservoir, not seepage into the well casing. Now, the relevant evidence of the gas tester is given in the main by Mr. Cadogan.
So your point on that is it simply doesn't support what the House has said about it.
Indeed. Mr.
Wait a minute, it's not, just a minute, it's not that that's given as the source of it. It's page 143, which is 1169. Is that any help?
No, I gave that as an example of how careful one has to be with points made by the judge, by Justice of the Peace Smith.
Yes, but the bit that Judge Smith quotes is in fact at the top of 1170, isn't it?
Yes.
And it is there. About punching a hole through the reservoir, line of least resistance.
Well, I think on that we made our points on that in our case. I don't need to expand on that.
But there was also evidence of the geologist on this, which the judge relied on. This time was the Archie, wasn't it, like that? Anyway, you don't need to go on it now. You've got to get on.
Mr. Archie is the geologist.
Yes.
And
But don't worry about it.
who was giving, who made it clear in his evidence that he hadn't actually visited the site. He was dealing with the matter generally, but he is familiar.
Yeah, I see, okay.
He was familiar with the local geology.
Well, don't take that one.
Yeah.
What I'm doing.
And Mr. Cadogan deals with his testing in his second statement, which is in bundle 3 at tab 22. And at page 619, he says in chief that with the use of a gas tester, he's describing the operation, and he says in 7, with the use of a gas detector, I then tested the well bore for combustible gas in order to issue a hot work certificate for the contractor to cap the well. This is done by welding a metal plate on the top of the well. A pole is then welded onto the metal plate with a sign identifying the well. He then exhibits the certificate. In paragraph 8 is important. He says, since the re-abandonment operations, I visited the well site on several occasions over the last 2 years. That's 2006 to 2008. His last visit was on the 27th of February. I've seen no evidence of any seepage of oil or hydrocarbon substances at the well site since the re-abandonment operations were carried out. And it was not put to him or to any of the, or to Mr. Roop Chan, who visited between 99 and 01, or to Mr. Sangasingh, who visited between 01 and 05, or to Mr. Julian, or to Mr. Jarawan, who were involved in 2006. It was not put to them that when they arrived at the site before they carried out the work, there was the heavy smell of oil or natural gas in the air. Mr. Cadogan's goes on, says in paragraph at page 61, he deals with that at 619. In his oral evidence, he says at page 1154, there's 2/3 of the way down. Does that suggest that before the well bore was sealed with cement the first time, that vapours were coming out of the well bore? Before the abandonment process, no, there was not any vapours coming through the well bore. The judge said there are no vapours coming out before the re-abandonment process, no. And over the page, at the top of page 1155, he says, before we started the whole process of re-abandonment, we had to weld a flange to accommodate a piece of equipment called the blow-up preventer. And the judge said, so you did your gas testing. We did that, and there was none. So they were able to weld the flange. At 1156, at the middle of the page, it was put to him that he was only testing gas on a single occasion. Answer, we tested for gas twice, for fire and explosion prevention. What are you looking for in a gas reader? If any levels of gas that would cause an explosion. And other than these 2 occasions, did not test for gas, no. And then he says at the bottom of the page, he tested for methane, 4-gas tester, methane, oxygen, and over the page, hydrogen sulfide, sulfur dioxide. At no time did I get any reading. He then explains the different, what would be appropriate or inappropriate. So, for example, with oxygen, it's 20.8%. With SO2, it's 10 parts per million. And then halfway down the page, court asks question, apart from methane, what other hydrocarbons exist that are combustible and in gaseous form? Answer, well, even H2S and SO2 is combustible gases. So the hydrocarbon gases identified in this case are combustible. He says, no, I know what was tested for, but not by me, was volatile organic compounds within that is a combination of other gases. So someone else tested for other VOCs. And at the bottom of the page...
we were here about an hour ago. This is surely testing within the well, not in the environs of the well.
It's in and around the well because they're carrying out a welding operation. There's no point in just testing in the well if 5 yards behind you, you've got a stream of natural gas coming out of the ground. But I think there
were not any vapours coming through the well bore, because what they were focusing on. Would it be safe, or might there be an explosion when they put the metal lid on it?
He's clearly having to use his judgment as to the area at which he is testing, and the and I do remind my lady and my lords that it was the respondent's case that the fumes and gas they complained of came from the well. I've already shown you this in their evidence, and that was their central case. If you look at their pleading, everything bar one item is focused on the well, and the one item was testing in the vicinity of the well. But it's not suggested in their pleaded case that there was natural gas that would come up in the area immediately around the well prior to 2006.
He seems to have tested, page 1158, tested 20 to 30 feet from well bore.
I'm much obliged. Yes, I didn't mark that.
So this point was it looked at? Did
Yes.
you say you didn't test 50 feet away? No, but did test from 10 to 30
In fact, if we can just go back to 1157, the bottom of the page, he said, at no time did I get any reading for any of these, and then he reads them off, methane, oxygen, H2S, it should be, and sulfur dioxide. By reading, it's obviously an adverse reading, and he was asked, so the tests are working. At no time did I get any reading for methane, H2S, SO2, would register 20.8 for oxygen, which is, of course, what it should be. If he got 0 for oxygen, he'd know his machine is broken.
Well, nobody's suggesting that oxygen's a problem.
No. But if this is being mentioned presumably to demonstrate that the machine was working.
Well, no, it might be a fire risk. It just isn't a lung risk.
Yeah, but the point is, if you don't pick up oxygen, your machine can't be working.
That is
There's that as well, yeah. Anyway, is the point about what Judge Smith said about all this at paragraph 37?
He's just got it wrong. Again, after the word rephrase in the middle of page 158, those gases were tested for. Once none detected, there were none.
Whereas the judge said that he'd only tested for methane.
Indeed.
Is that the point?
That's it. And he said he would have tested the well bore and the surround immediate area. It was put to him, didn't test 50 feet away, no, tested 20 to 30 feet from the well bore. Well, there's no evidence that suggests that the appellant's land extended beyond that 30-foot radius. In fact, we know that the respondent's home is about 45 feet from the well bore. Noticing the time, I want to wrap up our submissions in this way. Whether or not there were oil fumes and or natural gas from whatever source in the vicinity of the respondent's home that entered their home and led to an unhealthy atmosphere there is a question of fact. Of the evidence heard by the judge, the only witnesses who supported that were Mr. Ryan, his daughter Athena, and his friend Mr. Solzano. Their evidence was clear that the well leaked both before and after the 2006 works, and that leaking oil led to oil fumes permeating their home, right down to the trial. The only other person ever who smelt anything was the unnamed employee of the appellant who lived in the village and who in 1999 reported, in the words of Mr. Roop Chan, which were not challenged in his evidence, he says it at paragraph 5 of his statement at page 609, that he, the employee, had detected a slight odor in the air. And that came from oil seeping, not from the well, but from the vicinity of the well, and that led to the pit and its drain and its regular inspection and emptying, which the judge held represented a reasonable way of dealing with that nuisance, and there was no appeal from that finding. The judge rejected the evidence of the respondents and Mr. Solzano. He was entitled to. He was entitled to test their evidence as to what happened before 2006 by reference to the credibility of what they were saying had been happening after 2006 down to the date of trial. Mr. Cadogan, as I've shown you, said that there was nothing to be smelt after 2006. There was plenty of evidence to show that the capping of the well had been successful, that the area immediately around it had had cement pumped into it to prevent any gas coming up from the reservoir 1,000 feet down through the sands. The judge went to smell for himself. And as a result, and on the basis of all that evidence that I've just summarized, he came to a conclusion that was open to him. And the majority, we say, were wrong to have reversed it. And if we succeed in that submission, that is the end of this appeal, because if there's no gas, even if there is a scientific, clearly proven scientific link to oil fumes, to hydrocarbon gases, and the respondents' medical complaints, that would be irrelevant if, in fact, there was no relevant gas. I should, in my summary of the evidence, also have included the prevailing winds. You would have to have not just small whiffs of some kind of these gases or other VOCs, which were not explored at all in the evidence, but there'd have to be something persistent and significant to overcome the prevailing winds. If we fail on that, we say that the judge was entitled to come to, on the evidence he heard, to come to the conclusion that he reached on the medical evidence. not a single, well, one does not know what research was carried out by Dr. Trotman. We just saw her conclusion that she knew of no text that linked hydrocarbon gases and the respondents' diseases. Dr. Bagan Khan said otherwise. She promised texts, but when it came to it, it was that one book which includes the first respondent's condition, albeit using a term not familiar to Professor C. Mungle, but it's unattributed. We don't know where it comes from. Dr. Bagan Khan couldn't assist. The textbook would not appear to be a leading text because it wasn't one that was mentioned during her 9-month course here in London at the Faculty for Occupational Health. Dr. C. Mungle did carry out a comprehensive search for any paper on the subject. He found none. And he had no clinical experience himself of such a link. All that was put to him in cross-examination was that table. You've heard my submissions on that. And the journal article of the Korean study in the petrochemical complex, where there's no reference to hydrocarbons. Whoever carried out that study didn't identify the vapors. We simply do not know what are the vapors that you would experience in a petrochemical complex. The burden was on the respondents to establish that link, and their experts, the judge was entitled, having heard all the evidence, to reach the conclusion that they hadn't demonstrated it on the balance of probabilities, that at best the jury were out on that issue. So if we fail on the gas, in our submission, we should succeed on that second issue, namely the judge's conclusion on the medical evidence.
Would you invite us, or expressly not invite us, to draw any conclusions from the comparative qualifications of Dr. Bagan Khan and Dr. C. Mungle? I mean, on the face of it, Dr. C. Mungle is much better qualified than Dr. Bagan Khan, on the face of it, but...
I'm only pausing because on an issue of Maltese law that arose in a case I had a couple of years ago, the judge in question preferred the assistant lecturer at the law faculty of the University of Law to the professor and dean and head of the department. So it doesn't necessarily follow that because you have more qualifications, but being an academic who researches chest and lung diseases as well as seeing patients, and who knows how to carry out a search for papers, that deserved the weight that the judge gave to it. But I don't make a submission that because of the better qualification, his evidence should have been preferred.
But anyway, the point is the judge did prefer it.
He did, and there was material...
But you say the Court of Appeal were not entitled to reject it or regard it as discredited.
And especially where you have got an expert, Dr. Bagan Khan, who makes no reference to any source in her reports, who promises texts in the plural, and then turns up with a book with one word in a table. That is, the judge was entitled to say that he does not accept that evidence as proving the link. And the only other point I make is Dr. Bagan Khan did not suggest that she had had other clinical experience of patients suffering from hydrocarbon exposure who had developed this form of lung disease.
It does seem a little odd. I mean, people have been living next door to or near oil wells or oil installations for a very long time.
Yes.
And presumably people have been very concerned about possible medical connection. I'm a bit surprised there isn't sort of something slightly more convincing either way, actually, and that it's all left to this rather sort of...
Lord, I did wonder about that, and the answer I gave myself was the following. If I lived near an oil installation, whether active or disused, and I started smelling oil or gases in the atmosphere, and they came into my house, I would be complaining long before any point where it might be a danger to my health. It would be a thorough nuisance.
Yes, I was less concerned about your reaction.
Yes.
The fact that presumably this sort of situation has been going on for donkey's years, and one would expect there to be some literature about it either way. But
my lord is right. One would expect employees of oil companies who are exposed to oil, such as Mr. Ryan, who spent 15 years at the tank farm.
Well, I mean, experience shows that people don't complain. That's why industrial diseases tend to develop over years. But what does tend to happen is when you've got volatile or chemical substances around, is that there's some serious research about it, doesn't it?
Well, the Korean study is serious research.
God.
That's the only thing there is.
Yes, but I should add, just to save you reading the Korean study, it did not involve any kind of medical tests or investigations. It was based on very comprehensive questionnaires that were provided to employees. And in fact, the largest cause of lung disease experienced by the employees of this petrochemical complex was as a result of smoking. The final point that I address or the penultimate point I address, is any connection between gas emanating from the oil well or the area immediately around it, and assuming there was such gas, and assuming that the medical link is established, we submit that nevertheless the respondents that the judge was entitled to conclude that the respondents had not satisfied him that such oil fumes as there may have been over the years, or such modest amounts of natural gas as might have come up through the sands, were responsible for the medical conditions of the respondents. If there had been such fumes and or gas, it would have been of low density, carried away by the prevailing winds, and thus neither the respondents nor their neighbours would have been much troubled by them. That leads me to the Bonington line of cases, which I can deal with very shortly. They are only relevant had the trial judge or the Court of Appeal or this board come to the conclusion that there were fumes or gases or vapours coming from the oil well or the area immediately around it. There were other fumes or gases coming from elsewhere in the area, and you couldn't say which was the sole or predominant cause of the respondents' complaints. Well, in that event, we would accept that Bonington would apply. But it's a long, long way from the facts of this case.
Well, before Bonington turns up, you've got to have at least some guilty gas.
Indeed. That's much more succinct way of putting it. Yes. Can I assist further?
Do you wish to stay on your feet until 2 o'clock in case a further
I would be very grateful for that opportunity.
30 seconds worth occurs to you, Mr. Taylor?
Indeed.
Well, we will give you that opportunity.
Thank you very much, Mary.
Adjourn until 2 o'clock.